Hey everyone, so today we are going to be talking all about US immigration. I will be answering your questions. Some of you already sent me questions in advance, so I'll be answering those. If you're joining me live, put your questions in the comments. And then if you're watching this on the replay and you have questions that you need answers to, go ahead and put them in the comments. I am more than happy to answer your questions. I am a US immigration attorney and I help my clients get green cards and citizenships for themselves and their families using the US immigration law system. So go ahead and hit me with your questions. Like I said, I have questions that came in advance, so I will be answering those. But if you're watching live and you have your own questions, put them in the comments. I will be answering those as well. As you're coming in, feel free to say hi and where you're watching me from. I am so happy that you are joining me. So, without further ado, we're going to get started. The first question is, how long is the time frame between when you go to your medical exam without your vaccines to then going to your interview and asking to qualify for the waiver? Also, are you bringing all your evidence required to the initial medical exam or only to the following interview? Thank you. So, this question is talking about people that have objections to taking vaccines required for the medical exam. So, when you are applying for a green card, you are required to do a medical exam. If you do not want to do the vaccines that are required, again, there are certain vaccines that are required by the U.S. government for everyone that's applying for a green card to get in order to basically get a green card. If you object, so during COVID, when the vaccines came out, people objected to getting the vaccine, and there's a waiver available, right? You can apply for a waiver if you object to the vaccine. Now, this person is asking, what's the sequence of actually applying for the waiver? So basically, you have to do your medical exam. The physician that does your medical exam will note on the form that you qualify for a waiver, or you will tell them that you are going to apply for a waiver for the vaccine. They'll make a note of that on the form, right? That's all you're doing at the medical. Then, when you get the report, you're sending that into USCIS for your application, and you can do one or two things, right? At that point, because you know you don't have the vaccines required, you can choose to apply for the waiver right then, right? You can do the form I-601 waiver. You can apply for the waiver for the medical, include all your supporting documents, statements, medical reports showing why you're not wanting to take the vaccine, any reports that show that you have continuously not taken vaccines in the past, and this is just in line with your regular behavior. You can include those evidence with the I-601 waiver at that point. Or you go to your interview if you're scheduled for an interview, and the officer reviews your medical, sees that you didn't take your vaccines, and requests that you file a waiver. You leave the interview and then you file the waiver with the office that's required, that you have to send the application to. So you're not filing the waiver the same day as your interview to the officer, because the waiver has a filing fee and the officer cannot accept the filing fee. So, in order for you to properly file an I-601 waiver for the vaccine requirement, you must file it to the right address with the right filing fees. Okay, you are not filing the medical vaccine waiver with the officer. It will eventually get to the officer, and the officer will make a decision on it. But the officer is not the one that's going to take the payment, accept the application, give you a receipt notice. That's not their job. So if you know before you even file your green card application that you're not going to take the required vaccines, you might as well do the medical, the waiver with the green card applications, just so everything is processing. So basically, if you want to do it that way, which is what I typically suggest, you file the I-601 waiver, you include the medical exam, right? Because you need the medical exam to show that you didn't have the required vaccines. You file your green card application with the medical exam report, with your I-601 waiver, and the appropriate fees and supporting documents. This way, everything is processing at the same time. If the officer decides to schedule you for an interview, they already have the waiver because it was part of your application to start with. They can actually make a decision on not just your green card, but also the waiver at the same time. But if you choose to wait until you have your interview, just know it's going to take more time. So if you want to reduce the amount of time, do it up front. All right. So the second question I have here is, I have multiple nationalities, Haitian and Ivorian, but most of my family are Haitian. Is there any other immigration process for me? So basically, this person is in a situation where they are Haitian and Ivorian, they're dual citizenship. And they are looking at the parole for Haitians. And unfortunately, because they are dual citizens, they are not able to apply for the parole because that's one of the requirements, is that you don't have dual citizenship. So because this person is in a situation where they do have dual citizenship, they're not able to apply for the parole. However, if let's say one of the family members is their spouse, let's say they're married to someone that's only a Haitian citizen, the Haitian citizen can apply for the parole, and then this person that's a dual citizen can also apply under their spouse, right? So even though they're dual citizen, because their spouse qualifies and is Haitian and it's not a dual citizen, they can still qualify under their spouse. So that is one of the things that they can do. Typically, if this person came to me, we would figure out all the other ways that they could possibly come. Also, depending on their age, if they are under 18, they can come under their parents. Children under 18 can qualify under their parents without needing to be just a Haitian citizen, right? If they are dual citizens, they can still qualify under a parent. But once you're over a certain age, you no longer qualify to be under your parents. So basically, marriage to a Haitian or having being underage will be a way for you to still get the parole without you on your own qualifying. Okay. Next question is, I'm a sponsor for the parole program. What documents do I need to upload? My taxes, US passport, and citizenship documents. So this person wants to sponsor someone that meets the requirements for the parole, and they want to know what documents do they actually need to provide. Well, simple terms, the person has to show that they have legal status in the US. So in this case, it looks like this person's a US citizen, so they need to provide documentation showing their citizenship. In this case, a US passport, right? But they also have to show their financial ability to support the person. All right. How do you show your financial ability to support someone? You upload your tax returns, your W 2s, your pay stubs, employment letters, things to show that not only do you have you had this income in the past, you currently still have this income. If you do not have a job, or if you're retired and you want to sponsor someone in this situation, you can also use assets. So your assets can be your house. If it's a house, you need to show the value of the property and if you have a mortgage on it. So basically, it's the equity that is the asset, not really the house itself. So for example, if your house is worth 300,000 and your mortgage on it is 290,000, it's only the 10,000 that's the actual equity, right? Is the actual asset that would be used in this case. All right. So you can use your assets, but you need to show proof of assets as well. So if it's stocks, you will need to show your accounts to show that you have enough in there that if you sold all your stocks, you'll be able to have that cash. All right. Um, all right, so this is the next question. I applied for EB3 visa. Now, because of the retrogression, I plan to conceive. Is it a bad idea? So this person is basically asking me if it's a good idea or a bad idea to have a child. That's not up to me, unfortunately, right? I can't tell you that. But what I can tell you is if you do have a child, your child can be included in your EB3 application because EB3 is an employment based green card application, basically. It's an employment based visa, it's an immigrant visa. You're coming here to stay. So it's something to keep in mind. So in those type of situations, you can have derivatives. So you can have children under you. So even if you do have a child after filing, when it's time to do the DS-260, when it's time to apply for the green card, the visa, you can add the child to the application. Okay. So just because you have a visa already pending, don't forget that depending on the type of visa, you can add your child to it once a visa becomes available. I know the retrogression was horrible, but once a visa becomes available, you can now add the child if you have already given birth. If not, then you just come to the US pregnant, right? But do not, you know, think that you're not going to be able to come with your child because most of the time that's the fear that people have when they are trying to decide whether to conceive or wait for the visa to come out is in most situations depending on the type of visa, unless you are an immediate relative of a US citizen, so that's children under 21, that's parents and spouse, right? Unless you fit into those three categories of people, you can always add your child to your application as a derivative, even if they are born after the application was filed. Okay, so if that was the concern, just know you will be able to come with your child. You just have to make sure to add them to your application. All right. So this person, the next question is, what about F4 green cards for brothers and sisters? Are the interviews being waived? So F4 visas for brothers and sisters of US citizens are taking forever, right? Some of them are taking 14, 15 years to be approved. Is the embassy going to waive the interview? No, the embassy does not waive interviews for initial visas. Okay, there are very tiny situations where the embassy will waive a visa interview, but not in the family based visas, right? Not in the immigrant visas. These people are coming here to get a green card and live in the US. The embassy is not going to waive their interview. That's just that's just how the embassies work. But but if they are in the US in valid status, when a visa becomes available to them, they can apply for a green card in the US by filing an I-485, and USCIS may waive their interview. So USCIS can waive interviews, embassies don't, okay, except for like in non-immigrant visas where someone is renewing. But in an immigrant visa, in this situation, the embassy doesn't waive the interviews. They will have an interview. But if they're in the US, let's say, the visa becomes available today and they're already in the US in, let's say, a B2 visa that's still valid or a student visa that's still valid, they can then apply for a green card in the US, and the USCIS can choose to waive their interview. So that's the only time where a brother and sister of a US citizen can have their interview waived. All right. So on the affidavit of support, people always have this question. On the income tax, what income do you include? Your gross income or your net income? This is a big one because a lot of people think that if they are self-employed, right? So if you're self-employed, you file a Schedule C. Your self-employment will have a gross income, right? Gross receipts, how much your business brought in. And then after you subtract all your expenses, it has a net income, right, for the business. So gross is everything before your expenses for a business, net is everything after your expenses. And this person is asking which one of those does USCIS use to determine your income for an affidavit of support. Short answer is neither of those. Okay, USCIS does not care about your gross income or your net income. What they care about is the 1040, the form 1040, and the line that says total income. So your net income on your Schedule C, right? Your net income on your Schedule C may say like $100,000. And then after, taking out all other things that you may qualify for as a business, the total income on the form 1040 may end up being like 20,000. Or your gross income may be, everything your business took in, maybe like 1 million. But after expenses and everything, it comes down to like 10,000. Right? And then your total income on the 1040 is 10,000. You see, so they don't care about your gross receipts. They don't care about your net income on your Schedule C. The only form they are looking at is the 1040 and your total income on the 1040. So if you have your tax return in front of you, typically it is the total income is line 9 on your tax returns. They're not even looking at your adjusted gross income. If you're in the US, most things that you're applying for, they will ask for the adjusted gross income. But for this, they are looking just at the total income. So it doesn't matter who you are, what you do for work. If you're a business, an individual, it doesn't matter. If you have a job, when it comes to the affidavit of support and your taxes, they are looking at the total income, not your Schedule C, not anything else. Okay, they're not even looking at your investments at that point. If the amount is not on the total income line on the 1040, they don't care about it. All right. So the next question. All right. I want to ask if endorsement temporary residence for 1 year means I have to stay in the US until I have my actual card with me in order to go out from US. Can I go outside the US before I have my actual green card, or is it going to be a problem? Okay. So this person came into the US with an immigrant visa. They have paid the fee to have their green card mailed to them, but they haven't received it yet and they want to know if they can travel. Basically, as long as you come into the US with your immigrant visa and you have the stamp, you have a 1 year permit, basically. So that visa will now serve as your green card for up to 1 year. So if you need to travel, a month after being in the US and you're still waiting for your green card to come in, you can travel with that visa because now it serves as a green card. The only thing to keep in mind is it's only for 1 year. It's only good for 1 year. So if on like month 10, you need to leave the US and you still don't have your card, you can leave the US, but just make sure you come back in before you hit that 12 months. Okay, that's really important before it expires because then you're going to have issues coming back in, and you want a smooth process. So if you do need to travel before you get your card, you can use the passport with the visa and the stamp, but just know you need to make sure that you come back within the time that it is valid for. Okay. So if you are finding this video helpful, please go ahead and like this video. And if you have questions of your own, please go ahead and put them in the comments. If you're watching live, I will respond to you right now. If you're watching on the replay, it's okay. Put your questions. I do go back and respond. And every last Friday of the month, we do our Q&A where I answer questions that came into me. And please go ahead and ask your questions. All right. Next question. When my husband, who is a US citizen, files for me, I am in the US, but my 3 children are outside of the US, ages 6 through 16. Can he file for them at the same time, or do I add them to my application? Great question. Great question. So, because the husband in this situation is a US citizen, the children cannot be added to your application. Your husband will have to file a separate application for each child. The good thing is, because the children are all under 18, they qualify as the step children of your husband. So your husband can go ahead and file for you here in the US and file for them that are outside of the US all at the same time. You don't have to wait for yours to be approved first before filing for the kids. It doesn't, one doesn't affect the other. So go ahead. Your husband can file for you and the children at the same time because they qualify as his stepchildren. Next question. What do you mean is your case, if your case hasn't been approved? Like if you already come into the US? Okay, so this person is asking specifically on the I-551. So when you come in, you go ahead and you have to pay an immigrant fee so that you can actually get your green card. So that's something people don't realize. When you get an immigrant visa, so let's say your husband files for you, you go to your interview, you are approved, you get the visa, you fly into the US, you're green, you're a permanent resident. However, the physical card, the permanent resident card, will not be mailed to you automatically. You will need to pay an immigrant visa fee to USCIS. And then USCIS will print the card and mail it to you. If you skip that step, you're not getting your card. So it's really important that once you get your visa, right? Once you get your visa, you can actually go ahead and pay that fee and get that process going so that it's already processing before you even enter the US. Okay. But if you do not pay that fee, just know your card is not coming. And until it comes, your only proof of your status is the stamp and your visa. And that's only good for 1 year. After the 1 year and you still don't have your card, you need to make sure that you are following up and that you are making sure that you pay that fee. Again, your card is not going to be mailed to you unless you pay that immigrant visa fee. USCIS does not play. Okay? USCIS does not play when it comes to getting their money. So make sure that you pay your fees. All right. So once you receive the travel authorization under the parole program, what do you do? Great question. So depending on where you are, you need to be ready to go. Basically, you need to be ready to come to the US. At that point, once you have the authorization to travel, you get your stuff and you travel to the US, right? You make sure you get your flight and let your people know that you are coming. You have 90 days to enter the US. Okay, so once you get your authorization to travel, you have 90 days to actually physically enter the US. You have to fly into the US. You cannot go through the border. Okay, you need to get on a plane. and then fly into a city in the US. And you have 90 days to do that. If you're getting close to your expiration of the 90 days and you're not able to travel for whatever reason, you need to contact CBP immediately, right? Immediately. Once you find out that you're not able to travel, you need to contact them and ask for an extension. Okay. If they don't give you the extension, just know you need to travel. If you do get the extension, you only get one extension. So please use it if you get it. But if you're going to be applying for the parole program, know that once it's approved, 90 days, you need to be in the US. Okay. All right. So the next question I have is I have my receipt notice. My receipt number is showing that it's invalid when I try to search it on the USCIS website. What do I do? Great question. So when you file any application with USCIS, you get a receipt notice that has a receipt number. That number is there for you to be able to follow up on your case, check what the current status is, all of that. If you're putting it in online and it's not showing up, what you need to do is call USCIS. Unfortunately, that's what you have to do. So you can either call USCIS or go on uscis.gov and do the ask Emma and ask for a live agent, right? Having a live agent is basically the same as having someone on the phone, except it's a chat, right? So call or use Ask Emma to figure out why your receipt number is showing up as invalid, because the customer service rep that picks up will be able to check your case by your name, your address, believe your phone number. They can gather all the information about you, put it in their system, and see what case is pending. If the receipt number is not correct, they will be able to give you the right receipt number for you to be able to track your case. So if you are getting if you're putting in your receipt number and it's showing as invalid on the USCIS case status, go ahead, call or do Ask Emma, ask for a live agent, and find out what's going on with that. Again, they're able to look up your receipt or whatever application you have pending with them by your name, address, and all the information that they can gather from you based on what you filed. Okay, so if you filed your application and you were living at one address and you haven't changed your address, make sure you're consistent with the address that you're giving USCIS if you do call or if you do ask Emma. All right. If you have questions, please feel free to put them in the comments. I am more than happy to respond. And if you want to know how to check your case status, I have a video on how to check the case status and how to check your processing time if your case is going a bit too long and you're just not sure if it's normal or if it's, outside of the normal processing time. Go ahead, watch the video. You can check your case status and your processing time to make sure that you are still within the normal processing, and give yourself some peace of mind when it comes to the USCIS of it all. Like I said, if you have questions, put them in the comments. If you're watching on the replay, hey, put your questions in the comments. If you found this video helpful, please go ahead and like it, share this video. And as always, thank you so much for joining me. I'm a U.S. immigration attorney, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. If you would like to work with me or to just get a strategy session to see what you qualify for, and ask me your questions in private, you can do that by calling my office at 508-443-1788 or by going to my website, lillylegal.com, and scheduling a strategy session. Thank you and have a great rest of your day.